Hey guys, this is Michael Lutfi. I'm an attorney in Florida, New York, New Jersey, and Texas. Today what we are going over are the essentials for filing a Chapter 7 bankruptcy petition. This will be the first video of my series on bankruptcy law. Before we get started, I'd like to state that this is not legal advice and you should hire an attorney prior to filing for bankruptcy. Second, I'd like to add that all of the forms we will be going over can be found online for free, and I'll be having the links available for you in the description box below. So let's begin with the bankruptcy petition. First, we will start with Official Form 101, the voluntary petition for individuals filing for bankruptcy. First at the top, you'll see that we put in Southern District of Florida. We're going to be assuming that the person filing for this bankruptcy lives in Miami, which is located in the Southern District of Florida. The district in which you will be filing is all dependent on the region in whatever state it is that you're living is. Second, you'll see that we marked Chapter 7 bankruptcy is what we're filing under. Now, if you go to the first question, it asks for your full name. Here we've made a fictional person, John Smith. If John Smith were married, and if his wife did want to file for bankruptcy, that information would go right here. Now in bankruptcy, even if you are married, you don't necessarily need your spouse to file for bankruptcy. So that is something important to consider. Second question asks if you had a different name in the last 8 years. So if someone became married and they had a maiden name, they would be entering it in here. Third, you need to put in the last 4 digits of your Social Security, which we did. Next, it asks if you've had any business names and the employer identification numbers in the last 8 years. That will mostly be applicable to business bankruptcies in Chapter 11. So if there's an LLC or a C corporation or anything of that nature, that would be in this box, this area. However, if it's an individual, Chapter 7, that would not be needed to be filled out. Next, you need to put your address, which we've done. Next, you need to answer the question, why is it that you're filing in the Southern District of Florida? The most typical reason is that you've lived in that district in the last 180 days. So we checked this box, assuming that's true for John Smith. The next question 7 is asking the individual to identify which chapter the case is being filed. Again, here we've marked Chapter 7. The next question is indicating how the Chapter 7 filing fee will be paid. The Chapter 7 filing fee right now is $335. You have 3 options on how to handle that fee. First, you can pay the fee up front while at the same time you file the petition. Second, you can ask the court for permission to pay the fee in installments. Typically, you will pay half the fee up front, and then within 60 days of the filing, you will pay the other half. Lastly, you can request that the fee be waived. However, the fee will be waived almost always based on an income of 150% of the poverty line, whether you're below that or not. If you're below that, you will have the fee waived. If you're above it, you typically will not have the fee waived. The next question is asking whether you filed bankruptcy within the last 8 years. Here you can say we filled that out. Southern District of Florida, January 1st, 2017. And here's the case number. The reason why that's important is the following. If someone filed for Chapter 7 within the last 8 years and they received their discharge, that person cannot receive another discharge unless 8 years have passed. So if the individual filed for bankruptcy on January 1st, 2017, they will not be able to file again and receive a discharge until January 1st of 2025. Now the next question 10 is asking if the individual's spouse is connected with the bankruptcy. Here the answer is no. The next question is, do you rent your residence? in the facts we've made up, the answer is no. Number 12 is asking, are you a sole proprietor of any full or part-time business? Here the answer is no. And again, the courts and the Chapter 7 trustee are looking to see how you earn your income. When you file for bankruptcy, the most important thing is full disclosure of all of your assets, liabilities, incomes, and debts. So the court wants to know if you are working, is it as a sole proprietor? Question number 13 is asking, are you filing under Chapter 11 of the Bankruptcy Code? Again, no for our facts. Number 14 is asking, do you own or have any property that poses an hazard to the public health or safety? Now this question, as many other questions on the bankruptcy petition indicate, are only applicable to business cases. So an individual who has normal consumer debt, this would certainly be no, but you'll see that many questions repeat of this type of a nature. Number 15 asks, have you received briefing from an accredited counseling agency within the last 180 days? Basically, a credit counseling agency is designed to give you a course in which you have to spend about 30 to 45 minutes determining whether you should file for bankruptcy. If you don't take this course, almost always you will not qualify to stay in the bankruptcy case and you will not receive your discharge. Number 16 is asking, what type of debts do you have? It's asking if you have primarily consumer debts. Now, primarily consumer debts means that you've used credit cards or accumulated debts that are for normal everyday living expenses. So if you use credit cards for groceries, for medical bills, if you use credit cards for even vacations, those are consumer debts. Again, the next question, are you filing under Chapter 7? Here, the answer is yes. It goes on to ask if you're estimating that there will be exempt property. Exempt property means that you have certain property which is not protected under the state exemption laws. What state exemption laws are a certain set of rules that unsecured creditors, meaning credit cards, medical bills, and things of that nature, cannot take your property even if you legitimately owe the debt. So if you owe a credit card under Florida law, they cannot take your homestead property, which is the residence in which you live. That's just one example. Now the next question asks you to estimate your creditors, your assets, and your liabilities. And then at the bottom of Form 101, you can have an electronic signature or you can actually sign it and submit it to the court. Now if you keep scrolling down, the forms from the court actually warns consumers that you should understand that many people find it extremely difficult to represent themselves successfully. Because bankruptcy has long-term financial and legal consequences, you are strongly urged to hire a qualified attorney, and that is what we just said. Now the next form, Official Form 106 Sum, is a summary of your assets and liabilities and certain statistical information. Basically, this form is looking for you to add up your property, your liabilities, your income, and your expenses, just so that the trustee or the court can get a quick identification of the information on your bankruptcy case. And we're going to be going through that information later. So Official Form 106AB just applies to what property it is that you actually own. So this includes houses, cars, clothing, jewelry, It could also even apply to stocks, bonds, financial accounts, or even a personal injury action. But here, for this debtor, we started with his house. We listed the address. It's a single family home, and we estimated the value. Now, the value does not have to be 100% exact, but it does need to be listed in good faith. So if someone were living in a mansion and they put it was worth $25,000, that would most likely not be good faith. The same thing for a car. So here we put the debtor has a BMW 3 Series with 40,000 miles on it. We estimated that the car was worth $30,000. Again, it has to be on good faith. Now, if you keep scrolling through this list, you'll see there's a lot of different categories. The next one we put down was household goods. You need to give a general summary of what it is. So we put kitchen furniture, kitchen chairs, sofa, bedroom furniture, and things of that nature. Again, we estimated that $3,000. Then we have electronics. There's a section for artwork, for sports equipment, firearms, clothing, jewelry, and animals. Now, if you happen to own a dog or cat, you should keep in mind that most of them, even though they might be very important to you, we only are looking at the economic value of the dog or the cat or whatever the animal may be. Usually, this isn't very much. So then we go into the financial assets. The court wants to know how much cash you're holding on to, the deposits of money, checking accounts, savings accounts. So we listed that here. They want to know if you own any stocks, if you own any interest in a retirement plan, if you have any security deposits. So if you're renting your residence and you gave a security deposit to your landlord, that does need to be listed with the court. It could also even include tax refunds, which is also something that people seem to forget, and they don't realize that actually it is a financial asset with real value. Again, there's even a category for a personal injury action. As you can see here, we listed the value as unknown. Many times, if someone is in the middle of the lawsuit, they could lose the lawsuit and get nothing, or they could gain a substantial amount of money. If in good faith, as we previously stated, you don't know the value of your claim, you can simply put unknown. And then when you get to the bottom of Schedule AB for property, all of your assets need to be added up. And then you get to the final number of $190,950. Now the next form, which is Official Form 106C, deals with exempt property. As we previously stated, certain property is exempt from creditors, such as a homestead, so we listed that here. In the state of Florida, if your property is your homestead, meaning the house is something that you own and it is where you live, it is protected. Florida will also protect your car up to a certain amount. Florida will also protect other normal everyday living goods to a certain amount. Again, if you have too many assets, then your property could be subject to your creditor's claims and you might have to sell that property. It all depends on the facts of your case. Now next we go to Schedule D, creditors who have claims secured by property. So a secured claim is when the debt is directly tied to the piece of property, so that if you do not pay the debt, the creditor can reclaim that property to get paid. The most two frequent examples of this are mortgages and car loans. So here, first we listed BMW Bank of North America, which is a financial company. They have a $5,000 secured claim on the car. So what that means is that their interest in the car will not go away from the filing of this bankruptcy because they are secured. Similarly, on the house, we put Ocwen Loan Servicers. They have a secured claim on the house for $50,000. And we can see that the nature of the lien was an agreement that we made, such as mortgage or security loan. So we need to list them, even though their claim will not be discharged. We need to list them to protect the debtor through the bankruptcy process. Next, Official Form 106EF. This has to do with listing creditors who have unsecured claims. Now, there are two types of unsecured claims: priority claims and non-priority claims. Priority claims could include tax debts, which we listed here with the IRS. It can also include domestic support obligations. This means alimony or child support, which we did not put for this particular debtor. Now, if you are a priority creditor, or if there is a priority claim, what that means is that first, the priority claim gets paid 100% of their money before the non-priority claims. So the Internal Revenue Service will be paid before the credit cards are paid. So here, $10,000 is the IRS claim from back taxes, and they will get paid before the credit cards that we listed in Part 2. So you can see in Part 2, we put American Express. They're owed $15,000. We put the last four digits of the account number and when the debt was incurred. Also, another example of unsecured non-priority debt is a car repossession. Here we put AutoVest Financial Services, which is a company that deals with repossessions. If the car was sold for less than the secured amount of the debt, not only does the individual lose the car, but they still need to pay back the extra money that's left over from that debt. And you can see we put car repossession right there. Here's another credit card we listed, Bank of America, $45,000 credit card debt. Now, another form of a debt could be liability resulting from a tort or an accident. So let's say someone had car insurance, only $25,000 of liability insurance, and then they got into a car accident and caused $65,000 of damage. They will be responsible for that $40,000, which is exactly what we put here. State Farm Mutual Insurance, $40,000, and we put here specifying what this arose from. It was a car accident liability. Here is another credit card we have, Synchrony Bank, $22,000, with all the important information. So at the very end of this schedule, all of these claims need to be added up, and we added up. There's $10,000 of priority unsecured and $155,000 of non-priority debt. Next is executory contracts and unexpired leases. The most common category of loans or debts that fall into this situation are car leases. So here you can see we put Honda Accord 2018 EX lease, 3 years. If you do enter into bankruptcy with a lease, you do have the option to either what is called assuming the lease, which means that you will keep paying the lease and you will maintain your liability on the lease even after the bankruptcy, or you can reject the lease, get rid of all of the debt associated with breaking the contract, but you will have to give up the vehicle. Now next, Schedule H, we have your co-debtors. A co-debtor could be a co-signer on a loan, someone who is jointly liable with you for a car accident. It could be a many number of things. If you do have a co-debtor, you should be listing them on the petition, which is exactly what we did here. Also, you have to identify for what claims is this associated with. So you can see here, Schedule EF line 4.5, that is associated with the unsecured debt. Next, we have Schedule I, your income, Form 106I, is where you have to disclose how much money you're earning, who is your employer, whether you're employed or unemployed. Here, our debtor is a teller for Ally Bank in Miami. He's been working there for 10 years. Now, here's an important thing to remember. Even if you have a spouse who is not filing for bankruptcy, you still must indicate how much money your spouse earns. The reason for this is that the court wants to know your entire financial situation. And even if your spouse is not filing, the court needs to know how much he or she is earning. So here we went through all of the particulars of the individual's income. $1,200 per month, $50 in overtime. The gross income is $1,250. You have to also list all payroll deductions, which we did. Once you go through all of these individual line items, you do get a number on line 10 about the monthly income of the debtor. This $919.88 is the net monthly income of the debtor after all the deductions. And this is going to be the final figure that the court is truly going to be looking at when it comes to income. Another thing to keep in mind is that the income figure is the income as of the date of the filing. We are not looking at what your income would be 6 months ago, and we are not looking speculatively in the future what your income could be a year from now or 2 years from now. We are looking at what is your current income. The same is true of the next form, Form 106J, your expenses. We are looking at what is your current expenses now. So the first question is this a joint case? Meaning, is this a joint case with a spouse? No. The next question is, do you have any dependents? We put no, but if you did, then you would need to list them. So the individual line items of the expenses are similar to Schedule I. You need to list every line item of the expenses. And again, you need to be as exact as possible, and you need to make a good faith estimate of what your expenses truly are. So you need to list your rent, real estate taxes, homeowners insurance, utilities, food, and every other aspect of normal everyday living. Ultimately, we want to add up all these figures and then we get to a final number. 2,366 is our number. And then what the court will do is compare the income listed on Schedule I to the expenses of Schedule J, and then we get a final total monthly net or negative number. Here we're getting a minus 1,500 about. The very end of all these schedules, the court will ask that the debtor signs it under oath that this is true to the best of your information. Now we have an official Form 107, Statement of Financial Affairs. These Statement of Financial Affairs are asking many personal financial information just again to get more full disclosure about your financial situation. So again, we're going to ask, what is your current marital status? We're going to ask, where have you lived in the last 3 years, if not at the address which you listed in the beginning of the petition? Here, we gave a different address. You do not need to go further back than 3 years, just go back the last 3 years. Now, another question will be, in the last 3 years, meaning the current year and the 2 years before, what was your annual income for those years? So as of 2019, our debtor only earned $15,000, but then the year before he earned $25,000, and the year before that he earned $50,000. So that will need to be disclosed. Also, another thing to keep in mind is that many trustees will ask for the last 2 or 3 years of tax returns, so they can verify that your income is actually what you say it is. Now there's other questions, including certain payments that you made before filing for bankruptcy. So if someone made big payments to a particular creditor prior to bankruptcy, the court or the Chapter 7 trustee may look into those transfers. So here we're saying that right before we filed for bankruptcy, less than 30 days, the debtor paid $5,000 to American Express. The trustee might look into that transaction. Also here, if you make transfers to insiders, which means family members, the court could look at that. So here, the debtor made a $15,000 payment to his grandmother only a couple months prior to the bankruptcy. So this is something that will definitely be considered in allowing the debtor to receive a full discharge, or you could say forgiveness, of his unsecured debt. Another important question that frequently arises is number 9. Has the debtor been involved in a lawsuit within the last year? Here, the debtor has been, according to what we see. American Express sued the debtor in Miami-Dade courthouse over the collection of its credit card. It was a credit card lawsuit. Another important thing is question number 14. The court wants to see what type of gift giving you were making to family members or charity contributions. So here we put that there was tithing going on, and it was every Sunday, and in the last 2 years there was a total of $10,000 given to the church. That doesn't necessarily mean that something bad will happen if this did in fact occur, but the court still wants to know where the debtor's money was going over the last 2 years. Another important question, which is almost always applicable, number 16. This question asks the debtor what type of payments were made to either attorneys or petition preparers or other individuals to help the debtor with his or her debt situation. Here we put that the debtor made a $1,500 payment to his lawyer prior to filing for bankruptcy. This is completely acceptable, but the court still needs to know. One last important point from this form: the court will ask on the form whether the debtor has a safe deposit box. If the debtor does have a safe deposit box, the location of the safe deposit box needs to be disclosed and the contents need to be disclosed. This is what we did here. So when you're through filling out all the information on this and answering all the questions, you go and you sign it again. Now here, official form 108 is the statement of intention for individuals filing under Chapter 7. As you may remember, we had 2 secured debts with the car and the house. If an individual wants to retain the property and wants to continue paying the monthly payment, they need to do something called reaffirm the debt. And that means that the secured creditor will be unaffected by the bankruptcy filing, and the debtor will maintain liability on the debt despite the bankruptcy. So that is what happened here for the car and here for the mortgage company. And if the individual does want to keep the property, while there are a few other options, the reaffirmation is the main option to keep the property despite the fact there is a secured debt in Chapter 7. Also, as you may remember, there was a car lease. Here, we put that we wanted to assume the lease because we want to keep it. If we wanted to get rid of it, we could put no, the lease will not be assumed, and then we would have to give back the car, but we would release the liability of having the car. Then there is a statement about Social Security numbers, official form 121. Here you have to sign that you actually have a certain Social Security number. Here there's a Chapter 7 statement of current monthly income. If your income is below the tax guidelines for yourself and the amount of people in your household, then there will be no presumption of abuse. So here you can see we checked that. Because the $1,200 a month is under the guidelines, we indicated here that there is no presumption of abuse. The guidelines here state that an individual of one living in Miami-Dade would be $46,677. Here, the income is only $14,400. And then here, we have a verification of creditor matrix. This needs to be completed so the court can actually send a mailing to all of the individual creditors. So we have a verification here that this is the entire creditor matrix, which is what we did. And in the Southern District of Florida, we have something called Declaration Regarding Payment Advices. Payment advices refers to pay stubs. If you have pay stubs, it needs to be attached and given to the court. If you don't, then you need to explain under one of these reasons why there are no pay stubs. And with that, that is the conclusion of going over the forms for filing a Chapter 7 bankruptcy petition. Thank you.